Well, good morning, ladies and gentlemen. What brings water and gambling together? You could say it's a very strange thing, but if you look at the new European Commission and the debate that took place the last weeks on where gambling would go, namely would gambling stay within DG market and driven by the internal market principles, or would gambling go to what we call DG Connect and be driven by the digital agenda, where it seems that the compromise is that it stays with internal market, whether it will be in a unit covering postal, parcel, water, and gambling. So gambling and water, for whatever reason, have from a regulatory perspective something to do in the same unit. Having said this, it is, and I think it is not just a question in Greek that there is no model. I think there is in gambling, and I think gambling and those who are involved in it know that gambling is not about models, but is about passion. It's about passion, and it's about actually taking risks, looking at chances, opportunities, and I think gambling has been in the middle of an European debate, I think now for more than 20 years. It means I was there when in 1992 the first debate on gambling took place between the member states and the European Commission, the internal market of gambling, based on a study prepared at that time by Coopers and Librand, and where actually it was the UK government who said to the European Commission, this is not your business. And what we got there was actually the standard that has been set in 1992 in the Edinburgh European Council of heads of states and prime ministers, where they pointed very clearly subsidiarity is actually the standard rule that applies when we talk about gambling, which means that you regulate things at the most appropriate level. If it's local, it's local. If it's transnational, it's transnational. And that's actually the right way to look at subsidiarity. But it clearly was, at that time, the statement made by the Council of Heads of State saying, no way that we want harmonization in this sector. We are 20 years further today, and we can say, well, harmonization hasn't still taken place. Does it mean it will not take place? I think when somebody is involved in European policy making, you will always say, you know, you never know. This means, will harmonization will take place or not? It's something that is unpredictable from a European perspective. Sometimes it comes nearby, and at the moment that it's nearby, it can still be far away and things can change. What happened in the meantime? I think where politicians couldn't agree, the court has been facing a huge amount of cases. Since 1992, at the start of the Schindler case, we had an enormous amount. I think if you count them all in detail, it's not a matter of several dozens. I think we come today at around 40 cases that have been looked into by the Court of Justice of the European Union and the EFTA Court, if we add actually the cases addressing Liechtenstein and Norway that have been looked into up to now. Besides that, and actually as a result of this, member states were reflecting on the point that we cannot just have the court be sitting in the seat to regulate. The court is not a regulator. The court is there to interpret and to give guidance. But in the absence of any regulatory framework, the court is obliged, based on the treaty, actually to rule. And they do that, although you can see in the various cases that they have been handling, they want at a certain moment of time that the politicians take over the lead. They don't want to make policy. They want actually to implement the rule as they stand. And resulting of that was actually that member states were reflecting and saying, well, we need to start talking about this among the different people involved. And that gave rise to what was actually the work in the Working Party of the Council on Establishment and Services, initiated under the French presidency, followed up by a number of others, where we did actually have a kind of debate on various aspects of responsible gaming, illegal gambling, various issues that have been looked into by the Council. And it ultimately ended in the second half of 2010 under the Belgian presidency, where actually the Council could reach a conclusion And it's very important from the previous ones, because the previous ones, there was only a discussion. In 2010, there was unanimity on certain conclusions saying, altogether, we believe that these are the elements that need to be looked into. And one of the aspects was certainly, the role of the regulatory public authorities in supervision of gambling, compliance issues, effective enforcement that were in the key element in it. Also stronger cooperation. I think even IMI, the Internal Market Information System, was mentioned there, although it has not been implemented further. And there was also, for the first time, a specific issue addressing the role of lottery in society. What are the other things that we have on the table? Well, we have on the table a number of directives. This means it's not that nothing is regulated. I mentioned here the new fourth anti-money laundering directive, although it's not exactly final, but it is almost final. We have, of course, the audiovisual media services directive, where there is a lot of debate to what extent is it applicable. The preamble does mention that gambling is excluded, but that's only the preamble, so there is a lot of debate on that and a lot of discussion. The unfair commercial practices directive, which clearly is applicable, and more recently the concession directive that will have a very important impact on specifically, I think, casino concessions that will be regulated not only by the case law, like we have seen in the Dutch case, the Sporting Exchange case, and also in the Admiral case in the EFTA court, but will now be driven by a regulatory framework that is actually existing in the EU. Other initiatives are underway, and I mention here in particular two. One is the 2015 program on standardization, where actually standardization of the certification for online gambling gaming equipment is an issue that is on the table. I think it will even start earlier than 2015, since the first stakeholder meeting will take place still before the end of this year, in autumn. So that's an issue where we see that still there is debate, where issues of, I would say, a certain form of harmonization will take place. And on the other side, there is, under the Italian presidency, the whole debate shifted into another area of police and justice cooperation on how to address the question of illegal gambling and law enforcement. That are the rules that we have on the table. But beside those rules, there are other elements that are influencing the debate on gambling. And clearly, if you look even at other areas, and if you look at other policy issues in the European Union, you see a pattern that actually is taking place in gambling that is very comparable to what we see in other areas of European law, where there is an enormous amount of infringement cases that have been initiated. Where they will all go is not clear. I think the more there are, the more it looks to me that it's not a legal problem, but a political problem that is on the table, because the legal issues which are addressed there are not that straightforward or not that easy to handle, and I think will even be worse in the future when we talk about, the tension between the development of the digital agenda on one side and the OECD policy on the other side regarding base erosion and profit shifting, the whole taxation of the online environment. That is actually also a debate that is currently taking place, but at a larger scale, namely at the scale of the OECD. So there is this kind of tension. Now we see a huge number of infringement cases. Where are they going? It's not clear. The Commission has issued a number of letters of formal notice to Member States. Member States have replied, sometimes with hundreds of pages of answers, and that's where it is. It is somewhere in the unit, but I don't know whether anybody is looking at this further. At the moment, I think it is not moving forward because it's complicated. It's not just simply a straightforward issue. What we also see is that another process, what we call the notification directive, a very important tool of policy making, where member states need to send their draft regulation on technical standards on online activities to the Commission, and actually where member states can also intervene. We see that there is a larger aggressiveness coming from the side of the European Commission, whereby they question a number of issues. They question to what extent there is impact assessment made. They question why games are permitted or not permitted, why actually there are certain responsible gaming standards implemented. There is quite a lot of interaction what we see now from the perspective of member states, interaction between the notification processes and the pending infringement cases where things are interconnected, which actually is not the purpose of the notification directive. But we see this development from inside. A very interesting perspective at the moment, and something that is quite exceptional under European law. You all have probably heard about the fact that the Council of Europe did agree on a convention on the manipulation of sport events. I think for Sportradar being one of the sponsors here, it's one of the major achievements and very important for the development of their own activities. You know, it's the first time that the question of addressing match fixing has been looked into, but there seem to be elements that are considered to be controversial by some people, and one of the elements that is seen to be controversial is the question that in that convention a number of definitions have been provided. One of them is on the question what illegal sport betting means, and where it's linked actually to the jurisdiction where the consumer is located. As a result of that, and although actually the convention was ready to be signed in Macolin a few days ago, only 7 member states did sign, the Commission did not sign, and in total only 15 states did sign the convention right now, leaving actually the door wide open for where it can all go. Now the opinion 114 is a very specific procedure. This means under European law, beside the classic preliminary rulings that you all know, referrals from a national court to the European court, besides direct action annulment of a decision, a regulation, a directive that we see very often in relation to state aid cases and other matters, you also have actually the infringement cases, but one exceptional procedure is provided by the treaty, namely that a member state or one of the institutions can request the court a binding opinion on whether an international agreement is belonging to the competence of the EU to sign, or is a matter of shared competences, or whether actually it is compliant with European law. So you have a tension there between international law and European law, and the whole this question is, you know, what's actually having a higher standard. So this Article 218 procedure is actually, it's only the 23rd time in the history of the Union, of the whole European communities, that this procedure has been used. Therefore, it is of major importance, and we expect that actually the vast majority of the member states will intervene in that case, actually to have a debate on how can we actually look at this definition. Is it compliant with European law? Yes or no? It is a matter that is of major importance for actually the Convention on the Council of Europe and the debate in the future. So this kind of discussion, together with the digital agenda, together with the OECD procedure, which is again an external factor in the European Union, you get actually a framework where the different elements of the puzzle need to be brought together to find a kind of compromise where things can go. And then I come to the first big step taken by the European Commission within its action plan. As you know, Commissioner Barnier came up with an action plan saying, I want to address the infringement of the member states, I want to come up with a number of recommendations, and actually I want also to look into standardization. And in the process we see, okay, the infringement cases are there, although I think they are more on a parking lot than anywhere else. We see actually also the question of gambling equipment standardization moving forward, and at least we saw a first recommendation on the protection of consumers and users of online gambling, where they merged consumer protection with advertising into one big recommendation. Now, without going into the content, because of course the content is addressing a number of standards that have been discussed and that have been elaborated by the Commission, the whole question is, what does a recommendation mean? And is it something that the EU can adopt or not? Because also that is currently a matter that could be challenged. So, first of all, if you look at the treaty is very clear. The only thing that the European Union can do when it comes to consumer protection is actually adding value to what the member states are doing, and they can only do that to the extent that they pursue what is called a high level of consumer protection. And that's the first thing that we see, that a number of regulators question whether actually the content is responding to that criterion, whether it is actually pursuing a high level of consumer protection. The second element is that while A recommendation is a non-binding legal instrument from the Union. There is case law saying that while it's non-binding, it will have certain legal effects, which is a very complicated matter, but there is a case called Grimaldi where the court said that a national court needs to take the recommendation into consideration for interpreting the law as it stands. If they implement it, it's even more an issue. And we see that also in other areas. We saw very recently the recommendation issued by the European Commission in the energy sector in shale gas, where actually the same thing happened. There was no way to harmonize, to come to a directive on shale gas because of the opposition of a number of states, UK, France and Poland. Therefore, they shifted into a recommendation, hoping that this would actually settle the matter. And also there, it's a matter where there is a discussion, it's controversial because of the legal basis. Here, we don't know yet, but we know that a number of member states are currently exploring the possibility to attack the recommendation in court, to request the annulment, although from a very simple perspective they say, well, recommendation is not binding, therefore it cannot be challenged, but there are certainly other legal aspects, competence, conferred powers, issues that need to be addressed. To what extent is the Union competent to do so? Is it a matter of denying this? I don't think so. It's a matter of actually balancing the power between the various institutions. You know, can the Commission act alone, or do they need to take into consideration the other institutions, the European Parliament, with its democratic impact on the decision-making, and the Council of Ministers representing the views of the Member States? I think that's what is currently, I would say, at stake when it comes to this question of recommendations. You know? And of course we know that will be evaluated. But in the meantime, we have another angle that we see emerging more and more, and that's the question of competition law and state aid. I divide it into aspects because I think in markets where we see a certain form of liberalization of the market, there is actually tension that is raising about, you know, former operators in that market who were holding a monopoly, and a market that is actually opening. To what extent actually is there any risk of a violation of competition law? I think the French competition authorities have been looking into that. The Danish are looking into it. The Belgian competition authorities have been looking into that. You know, there is this kind of new area that needs to be settled as well, namely to what extent is there potential tension, and that will have an influence, of course, on the whole debate to what extent is a certain form of liberalization advisable or not. I think the more that actually there are risk of competition law, I see the more that member states could be tending towards keeping the monopoly as it is, because then they avoid these kind of problems. And I think it is an issue that everybody needs to look into, because, you know, advocating too fast for a form of liberalization could have the adverse effect because of competition law that member states would not do that. And I think it is an issue. On the other side, we have state aid matters. You know, state aid very much connected to different levels of taxation of online versus offline. We have seen the Greek casino case where actually they said, you know, difference in taxation. Here the findings of the European Commission have been annulled. We will see whether the matter will go further to the Court of Justice, because it was decided by a general court. And very recently we saw the Danish state aid case with a very surprising outcome, because actually the court denied to rule on the question. The court did not say, well, we accept a lower taxation for online or not. The court said, well, your request is not admissible because you're not individually or directly affected, you as operators on the land-based market. Therefore, you know, if you want to address this matter, go to the national courts and ask the national courts to refer it to the Court of Justice, because that's the right procedure to address the matter. This means the Danish state aid case, notwithstanding what has been mentioned in the press, is not settled at all. On the contrary, it just shifted to another level of court actually to address the matter. The General Court not accepting actually this action as a direct action in annulment, and that is actually the reality of this kind of case. So, where are we going with all of this? And how would you look at it? And I did not provide a slide for that separately on purpose, because I would rather say we have had 22 years, 40 cases, and we are not very much in a different situation than 22 years ago. The only thing we know, there is more clarification on what member states can do. And I think that also the Greek case is showing actually that, notwithstanding what the court has been ruling in the OPAP Stanley Bet case, where there is a lot of elements, very interesting elements, there is a lot of also elements that refer already to Schindler. This means between Schindler and Stanley Bet OPAP, there are a number of elements which are consistently the same. For instance, that the question of competition law, that competition in the market is not necessarily a benefit, is one of the elements that has been mentioned there. And strangely enough, I think in the Stanley Bet case, notwithstanding what was said years ago in the Winterwetten, the court did admit that, when there is a violation of European law, you will have time as a member state to find ways to become compliant. So this means there is a kind of transition period admitted. So where will it go? If indeed, as I said, you look at other sectors, and then you see a pattern, a huge number of infringement cases, soft law, recommendations, and a number of other forums where discussions are taking place, well, it's quite likely that in 5 years' time, we get a draft, at least, of, I would say, a gambling directive on the table. Will that be adopted? I'm not sure about that. It will actually depend on the political situation at that time. But I think that a lot of external elements are influencing that debate now that were not there before. And I mentioned the Council of Europe, Convention of Manipulation of Sport Event, which actually brings the level to another status. There is the discussion on how do we need to look at gambling on a global way, betting on a global way in relation to sport. Will it lead to actually a kind of, what I would say, an integrity contribution to be paid by all the operators, therefore actually affecting the way they do business? A battle that has been previously done under what I would call the IP rights, is there any obligation to pay for the use of sport data? I think this new dimension of manipulation of sport event could lead to another form of contribution, what I would say the integrity contribution. The OECD battle, which is actually very recent, what is called is BEPS, the base erosion and profit shifting issue, which is now a very big issue. We've seen actually Apple in Ireland, where the European Commission is starting an investigation to what extent is actually the low level of taxation not a form of illegal state aid. Is it acceptable that some online companies, that digital companies in the future, Amazon, Google, they are all currently under investigation to what extent actually they follow this line. And within the OECD, there is a clear stand that they want actually taxation to take place at the place where the consumer is located, where they see that the digital operators actually offer their services. These externalities will influence the online gambling debate as well, quite clearly. The division of powers inside the European Commission, where e-commerce moves to DG Connect, but gambling stays together with water. Why? Because they say, well, this is all very much connected to a form of public service, actually means also a shift in the thinking of the European Commission, at least at the level where actually decision makers divide portfolios. So where will the future be? I think it is a question mark, and it will be molded by the people in this room, outside this room, but actually by all the stakeholders involved in that debate. In any case, the only thing I know for myself and for all the others here, passion and emotion will continue at least for the next 5 years. Thank you.